So, you know the three branches of the US government, right? Executive, legislative, judicial. Seems solid. But what if I told you that one of them, the judicial branch, was basically just an idea on paper at the very beginning? Today, we're jumping all the way back to 1789 to figure out how the entire American court system was literally built from the ground up.
And this right here was the big question mark. I mean, the Constitution, it gave us the Supreme Court, which is great. But what about all the other federal courts? It was kind of silent on that. It basically left this giant, gaping hole in the government's design, and it was up to Congress to figure out how to fill it.
You could almost call it a constitutional cliffhanger. Seriously. Article 3 says, hey, we've got a Supreme Court, and then just stops. It basically punts the entire job of creating the rest of the federal court system over to Congress. So you've got this huge problem. No structure, no lower courts, and really no clear idea of how a federal case would even work.
So what did Congress do? Well, they got to work. They came up with the Judiciary Act of 1789. You should think of this as the architectural blueprint for the entire judicial branch. They were building it from scratch, and this was their plan. And the official name? An act to establish the judicial courts of the United States. I mean, it doesn't get much more direct than that, right? The goal was huge. To set up the courts that would actually enforce the laws of this brand new country. A pretty simple title for a truly monumental job.
Okay, so how did they actually do it? How do you build a court system out of thin air? The real genius of the act was its simplicity. It created this super clear, three-tiered system that finally brought some order to what could have been total chaos.
And this is what it looked like. A three-part judiciary. The whole idea was to create a really organized system that could handle all kinds of legal disputes, from small local stuff all the way up to major national issues. It created a real pathway for justice.
And what's so smart about it is how logical it is. You can think of it like a ladder. On the bottom rung, you've got the district courts. This is ground zero, where most federal cases get their start. If someone's not happy with the decision there, they can appeal and climb up to the next rung, the circuit courts. And then, at the very, very top, the court of last resort. You have the Supreme Court. So let's follow a case, right? It all starts in a district court. If there's an appeal, boom, it heads up to a circuit court. And if it's a really big deal, it might make it all the way to the Supreme Court. But, and this is a big but, only if the court itself decides to hear it. It's this clear, step-by-step path from the local level all the way to the top. Okay, so having a structure is great. A three-tiered system, perfect. But a structure without power is just an empty building, right? So the act had to do something else that was absolutely crucial. It had to give these courts some actual teeth. It had to define their authority and say, here is what you can do. And you can't overstate how important this was. Remember, before this, the Supreme Court's powers were pretty fuzzy in the Constitution. By spelling out its authority, the act helped turn the judiciary into a truly co-equal branch of government, one that could actually stand up to and check the power of the president and Congress. Part of that definition was just simple math. How many people should be on the Supreme Court? The act set the original number at 6. You had 1 Chief Justice and 5 Associate Justices. Now, of course, that number didn't stick forever. It's actually changed a few times over the years. And today, as you probably know, we've landed on the 9 justices that make up the modern Supreme Court. But it wasn't just about how many justices there were. The act gave the Supreme Court some very specific tools to do its job. And one of the biggest was something from Section 13 called a writ of mandamus. I know, it sounds super technical, but stick with me, because this little phrase had some huge consequences down the road. So what the heck is it? A writ of mandamus is basically the Supreme Court pointing its finger at a government official and saying, do your job. It's a legal order that forces them to perform a duty that they are required by law to do. Think of it as a way for the court to enforce the rules. It's a pretty powerful tool. All right, so we're talking about a law from 1789. You might be thinking, why should I care about this today? Well, because the framework it built didn't just disappear. It created a legacy that is still very much alive and kicking, shaping the entire American legal system as we know it. And this is the really wild part. That blueprint from over 200 years ago, it worked so well that it's still the basic foundation of our federal judiciary. That 3-part system of district, circuit, and Supreme Courts is exactly the structure we have today. They pretty much nailed it on the first try. So the Judiciary Act of 1789 was a game changer. It gave the courts their structure, their rules, well, They're everything. It put the judicial branch on equal footing, at least on paper. But that leads to one last nagging question. Having power written down is one thing, but getting the other branches of government, the president, the Congress, to actually respect that power, well, that's a whole other story.